Good morning, everyone. It is my privilege to welcome everyone to this lecture and panel discussion on arbitration in India, reform, relevance, and the road ahead. We are deeply honored by the presence of honorable judges, distinguished members of the bar, senior advocates, members of the legal fraternity, and students. Your presence today reflects the growing significance of arbitration as an indispensable pillar of dispute resolution in India. I am Muskan Nagpal, and it is an absolute honor to be a part of this forum dedicated to meaningful dialogue and legal insight. As India steadily strengthens its position as a global commercial and investment destination, arbitration continues to assume a central role in fostering business confidence, reducing judicial burden, and ensuring timely dispute resolution. At the same time, the arbitral landscape is evolving rapidly, with institutional arbitration gaining momentum, technological innovations transforming dispute resolution, and courts continuously refining the jurisprudence governing arbitral proceedings. Today's discussion seeks to examine these developments, reflect upon the progress made, and explore the challenges and opportunities that lie ahead in shaping the future of arbitration in India. Before we begin, allow me to brief everyone through the proceedings for today. We shall commence with the felicitation of our keynote speaker, Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India, and our distinguished panelists, Honorable Mr. Justice C. Hari Shankar, Judge Delhi High Court, and Honorable Mr. Justice Rajiv Shakdher, former Chief Justice of the High Court of Himachal Pradesh. This will be followed by the keynote address by Justice Bhuyan, after which we shall have the panel discussion moderated by Mr. Amit Gupta, Senior Advocate. The program will conclude with an audience interactive session, followed by a vote of thanks by Mr. Yashraj Singh Deora, Senior Advocate, and thereafter lunch. Without any further ado, let us formally commence today's event. It is indeed a privilege to welcome Honorable Mr. Justice Ujjal Bhuyan, Judge of the Supreme Court of India, whose judicial journey reflects an unwavering commitment to constitutional values and rule of law. Justice Bhuyan was elevated to the Supreme Court of India in July 2023 after serving as the Chief Justice of High Court for the state of Telangana. Prior to this, he served with distinction as a judge of the Guwahati High Court and Bombay High Court. Justice Bhuyan's ongoing tenure in Supreme Court has witnessed significant contributions to the development of India's arbitration jurisprudence. Through a series of important decisions, Justice Bhuyan has consistently reaffirmed the principle that judicial intervention in arbitration proceedings must remain narrowly confined within the framework of the Arbitration and Conciliation Act. His landmark decisions, such as Somnath Builders and CNC Constructions, Justice Bhuyan has consistently reinforced the principle of minimal judicial intervention in arbitration proceedings. His lordship has emphasized in his judgments that courts must not reassess contractual interpretations or reappreciate evidence merely because another view is possible, thereby strengthening the finality, certainty, and autonomy of the arbitral process. Justice Bhuyan's jurisprudence reflects a judicial philosophy that seeks to strengthen India's pro-arbitration framework while preserving the efficiency and independence of the arbitral process. We are truly privileged to have Justice Bhuyan amongst us today. Now I request Mr. Prateek Mehta to extend a warm felicitation to Justice Ujjal Bhuyan, Judge Supreme Court of India. Honorable Mr. Justice C. Hari Shankar, since his elevation to the Delhi High Court in 2017, has established himself as one of the significant judicial voices in commercial arbitration. Serving on one of the country's busiest commercial rosters, Justice Hari Shankar has authored an extensive body of jurisprudence under the Arbitration Act, addressing virtually every stage of the arbitral process, from the appointment of arbitrators and interim measures to challenge of the arbitral awards. Justice Hari Shankar has also delivered several important decisions clarifying the relationship between arbitral seat and venue of arbitration, legality of the unilateral appointment, party autonomy, and on jurisdiction of Indian courts in cases where the seat of arbitration is located outside India. Collectively, Justice Hari Shankar's decisions have significantly contributed to strengthening the predictability, efficiency, and institutional credibility of the arbitration in India. We are honored for your presence, sir. Now I request Ms. Mansi Kukreja to please extend a warm felicitation to Justice Hari Shankar, Judge, Delhi High Court. We are equally privileged to have with us Justice Rajiv Shakdher, former Chief Justice of the High Court of Himachal Pradesh. Prior to his elevation to the bench, Justice Shakdher enjoyed a distinguished practice in commercial, corporate, and taxation laws and is also a qualified chartered accountant. During his tenure at the Delhi High Court, he contributed significantly to the evolution of India's commercial and arbitral jurisprudence through several well-reasoned decisions. Justice Shakdher is a jurist who combines deep commercial experience with a modern principled understanding of arbitration, making him an exceptional voice on any arbitration panel. The underlying principle of Justice Shakdhar's judgments have been about securing the beneficiary of an award so that the manifest aim of arbitration as an alternate dispute resolution is achieved. Justice Shakdhar's judgments have consistently reinforced that arbitral tribunal is the master of evidence. Even after his retirement from the bench, Justice Shakdher continues to contribute to the dispute resolution through his appointment as an independent arbitrator in high-stake matters. We are privileged to have you, sir, with us. I request Ms. Soumya to please extend a warm felicitation to Justice Rajiv Shakdher, former Chief Justice, High Court of Himachal Pradesh. We are truly grateful to have such an eminent panel with us today. I now request Justice Bhuyan to kindly deliver the keynote address.
A very good morning to all of you. Justice Hari Shankar of the Delhi High Court, Justice Rajiv Shakdher, former Chief Justice of the Himachal Pradesh High Court, Mr. Amit Goel, all members of the Law Forum, senior advocates, and my dear students. It is indeed a great pleasure for me to deliver the lecture and participate in the follow-up panel discussion on the topic Arbitration in India, Reform, Relevance, and the Road Ahead. I congratulate the organizers for organizing this conversation on such a contemporary topic. Contemporary, I say, not because arbitration is contemporary, but because of the challenges that arbitration faces today in India. Friends, it has been 4 decades since the Arbitration and Conciliation Act 1996 came into the statute book. Despite initial aberrations in the form of judgments in Bhatia International and Saw Pipes, the jurisprudence governing arbitration, both domestic and international, has more or less stabilized. While there has been a series of decisions of the Supreme Court, including in SA Builders, which has clearly restricted the scope of judicial interference in arbitral decisions, except within the 4 corners of the statute, the principle of non-interference has been bolstered by the 2015 amendment as well as by the subsequent amendments. The principle of judicial non-interference is firmly established, at least that is what we believed. And this is a sound principle based on Article 5 of the Ancestral Model Law. Once matters are referred to arbitration, it is the arbitral tribunal that will deal with all issues of jurisdiction and procedure. The doctrine of competence stands firmly established. Throughout the world, it is acknowledged that the Ancestral Model Law establishes an efficient framework for arbitration with minimal amount of judicial intervention. In Som that Builders, Supreme Court reiterated that under 34, the court is not expected to act as an appellate court and reappreciate the evidence. Post 34, the restriction becomes more prominent. A great deal of restraint is required to be shown while examining the validity of an arbitral award when such an award has been upheld under 34. Frequent interference with arbitral awards would defeat the very purpose of the 1996 Act. In subsequent decisions in Consolidated Construction Consortium, as well as and other decisions, Supreme Court has said that an arbitral award is not liable to be interfered with on the ground that the award is illegal or erroneous, which would require reappraisal of the evidence. If two views are possible, there is no scope for a court to reappraise the evidence and to take the view other than the view taken by the arbitrator or its arbitral tribunal. The view taken by the arbitrator or arbitral tribunal is ordinarily to be accepted and allowed to prevail. Now, having said that, friends, I would like to highlight one or two issues concerning arbitration before I move on to an issue which I believe may irreversibly set the clock back insofar arbitration in India is concerned. There are other issues, but I will just highlight one or two issues here. The entire structure of arbitration hinges upon the impartiality and neutrality of the arbitrator. The 1996 Act has inbuilt impartiality safeguards. We know that. Notwithstanding the same, challenge to the impartiality and neutrality of the arbitrator continues to plague arbitration. In 2014, the International Bar Association came up with the guidelines on conflict of interest in international arbitration. These guidelines were incorporated in the 1996 Act by virtue of the 2015 amendment. Now, the 1996 Act contains sections 12.1, 12.5, as well as Schedule 5 and Schedule 7 that have provisions ensuring the impartiality of the arbitrator. So, at the textual level, India's statutory framework is not a watered down version of the international soft law. Rather, I would say it is a near direct statutory implant. On May 25, 2024, the International Bar Association approved an updated version of the guidelines while retaining the essence of the 2014 guidelines. Now they have come up with two varieties of red lists. One is a non-waivable red list, the other one is waivable red list. practically no for the arbitrator. There is an orange list and there is a green list. We need not delve into this aspect of the matter. India has not yet adopted the 2024 guidelines. However, the expert committee constituted to examine the working of the arbitration law and to recommend reforms in the 1996 Act has submitted a report recommending insertion of Section 12A in the new Arbitration Bill 2024 to ensure impartiality and to avoid conflict of interest. Subject to correction, this draft Arbitration Bill 2024 is not yet publicly available on the government website. The gap between Indian and international practices is not about the statutory framework. The gap is in engagement and culture. Indian law does not prescribe or require any code of conduct or ethical duties for arbitrators beyond the statutory disclosures. But Indian arbitrators rarely invoke the international guidelines. Therefore, it would not be out of sync to say that international guidelines function more as drafting inspiration for the legislature rather than act as living interpretive source for arbitrators on a day-to-day basis. Now, there is another issue, and this is the structural shift in the Section 34 jurisdiction itself. We all know Section 34 deals with applications for setting aside an arbitral award on the grounds given in the statute itself. One of the long-standing issues in this regard is the power of the court to modify an award in a Section 34 proceeding. Many commentators thought that Supreme Court had set the controversy to rest in NHAI versus Hakim by holding that courts under Section 34 cannot modify an arbitral award by varying the findings. It can only set aside awards. This was a view taken in Hakim. Now, Delhi High Court in NHAI versus Trichy-Tanjavur Expressway Limited observed that if an award comprises of separate components, each standing separately and independent of the other, there is no hurdle in adopting the doctrine of severability to partly set aside an award. While literally it would mean modifying or varying an arbitral award, in actual terms, it would amount to setting aside of an invalid portion of the award which can be severed. Such an exercise of jurisdiction would be valid under Section 34. This view of the Delhi High Court has been approved, endorsed by the Supreme Court, by the Constitution Bench of the Supreme Court in the recent judgment in Gayatri Balasamy. On the issue of court's power to modify an arbitral award, the majority, it's a judgment of 4:1, the majority has held that the courts may exercise limited powers to modify arbitral awards under certain specific circumstances. And they have noted down certain specific circumstances, such as when the arbitral award is severable by severing the invalid portion from the valid portion, to correct clerical, computational, or typographical errors which appear to be erroneous on the face of the record, to increase or decrease the post-award interest where the circumstances justify such alteration. And then exercise of Supreme Court's powers under Article 142 of the Constitution to pass orders for doing complete justice in consonance with the fundamental principles and objectives underlying the 1996 Act. In my view, Gayatri Balasamy has literally opened up a can of worms. It has opened up the window, in my view, for increased judicial interference in arbitral awards. The expert committee has also gone into this aspect of the court's power to modify or vary an award, as if following from Gayatri. It has proposed amendment of subsection 2 and subsection 2A of section 34 by suggesting substitution of the phrase set aside by the court with the phrase set aside in whole or in part by the court. It has also proposed addition of a proviso for partly varying the award in exceptional circumstances. Though the expert committee has suggested that such modification of awards should be only in exceptional circumstances within strict parameters, I am afraid it will only add to the already heightened tendency to judicially interdict arbitral awards. As if that is not enough, an amendment is being proposed for introduction of an appellate tribunal under section 34 by proposing establishment of 2 fora for adjudicating challenges to arbitral awards, the courts and the appellate arbitral tribunal. The proposed amendment makes good reading by providing party autonomy to choose either of the 2 fora. It sounds good on paper. And though the intention behind the proposal to establish appellate arbitral tribunal appears to be reduction of judicial interference, I am afraid, given the judicial history, this will only add to more and more judicial interference. In fact, constitution of such appellate arbitral tribunal may not achieve its intended goal of reducing judicial involvement and expediting dispute resolution. Rather, it may end up adding one more layer of adjudication besides enhancing judicial intervention. Friends, one judgment which has caused, I would say, the most extensive damage to arbitration in India is the 3-judge bench decision of the Supreme Court in Delhi Metro Rail Corporation versus Delhi Airport Metro Express Private Limited. In an unprecedented move, in April 2024, the 3-judge bench exercised its most extraordinary curative jurisdiction under Article 142 of the Constitution to set aside a high-value arbitral award more than 7 years after it was passed. This was not only after elaborate exercises under sections 34 and 37 were over, but even after exercise of Article 136 jurisdiction and the review thereafter. In curative jurisdiction, Supreme Court undertook a detailed review of the merits of the claims and reappreciated the evidence in what was effectively the 5th round of challenge to the arbitral award. While declaring and clarifying, as usual, that exercise of curative jurisdiction should not be adopted as a matter of ordinary course, lest it opens the floodgates and create a fourth or fifth stage of court intervention in an arbitral award. And despite reiterating the limited scope of interference with an arbitral award under 34 and 37, the bench did just the opposite. It has set aside a judgment of the Supreme Court passed under Article 136 of the Constitution of India by saying that the Supreme Court in the earlier judgment had restored a patently illegal award causing grave miscarriage of justice, terming the case to be an exceptional one. Therefore, on the ground of patent illegality and grave miscarriage of justice, Supreme Court has set aside an arbitral award exercising a jurisdiction created by itself, that is curative jurisdiction. Indeed, I would say this is an exceptional case. This judgment has raised serious questions regarding the extent of judicial intervention in an arbitral award in India, further raising questions about India's suitability as an arbitration hub for commercial disputes. Arbitrators and critics are aghast. They are shocked. This judgment is a clear case of judicial intrusion into the domain of arbitration, much beyond what is prescribed by the statute. And it has triggered all the consequences, intended or unintended, desired or undesired. This Delhi Metro judgment was delivered on April 10, 2024. Taking a cue from this judgment and immediately thereafter, the Finance Ministry issued an office memorandum on 3/6/2024 after highlighting the benefits of arbitration. This office memorandum goes on to say that the experience of the central government in respect of arbitration, where the government or a government entity or agency, such as a public sector undertaking, is a party, has been unsatisfactory. One of the grounds given is that the benefit of finality has not been achieved because a large majority of arbitral decisions are being challenged in courts, ignoring the fact that most challenges are by the state when state is one of the parties to the arbitration. Therefore, this office memorandum says that instead of reducing litigation, arbitration has virtually become an additional layer of adjudication, thereby delaying final resolution. It thereafter points out that with the enactment of the Mediation Act 2023, the government should go for mediation as an alternative to arbitration. But what is more disturbing is that by way of this office memorandum, certain guidelines have been issued for the government, its entities and agencies. In substance, the guidelines mandates that arbitration clause should not be included in the contracts and tenders. Arbitration should be restricted to disputes with a value of less than rupees 10 crores. Government departments or entities or agencies are encouraged to adopt mediation instead of resorting to arbitration. This marks a sharp, sudden, and controversial policy shift against arbitration. I understand that the Arbitration Bar of India had sent a formal representation to the Finance Minister, but I am not aware of the outcome of such representation or what followed thereafter. This issue was also raised in the Lok Sabha on 22nd July 2024, and in response to a query by one of the members of Parliament, the Minister of State for Finance, he defended the office memorandum, saying that it is based on unsatisfactory experience of arbitration in respect of high-value contracts, where the government or a government entity or agency, such as a public sector enterprise, is a party. Friends, at this juncture, let us travel a few years back. I think in 2016, there was a conference in the Supreme Court titled National Initiative for Strengthening Arbitration and Investment in India. The Prime Minister of India was present there, and he delivered the keynote address on that occasion, where the then Chief Justice of India, Justice T.S. Thakur, other judges of the Supreme Court and the High Courts, they were present. The Prime Minister emphasized 2016 on creating a vibrant ecosystem for institutional arbitration as a top government priority, because he was of the view that availability of quality arbitration mechanisms is an integral component of ease of doing business, to which, he said, Government of India is committed. He said, and I quote, "Creation of a vibrant ecosystem for institutional arbitration is one of the foremost priorities of our government." Prime Minister Modi said on that occasion that India has no dearth of brilliant lawyers and judges. India also has a large number of retired judges and engineers who can function as competent arbitrators. He declared that India's economic interest would be better served by having a higher number of arbitration experts and lawyers. The Prime Minister said we need to promote India globally as an arbitration hub. He also said that we should deliberate on ways and means to supplement the efforts of the judiciary and arbitration mechanisms. For this, he pointed out the potentiality of mediation. As a follow-up of the Prime Minister's declaration, the government had brought forward the India International Arbitration Center Act 2019. Initially, it was titled as the New Delhi International Arbitration Center Act 2019, for the purpose of creating an independent and autonomous regime for institutionalized arbitration and to make India a hub of international arbitration. India International Arbitration Center, of course now it is lying vacant, there's no chairman there. Earlier, till recently, it had a retired judge of the Supreme Court as the chairman, is a creature of the 2019 Act. Subject to correction, it has not taken any initiative in this regard, though one of the functions of this center is to bring in reforms to develop itself as a flagship institution for conducting international and domestic arbitration in India, and to facilitate the conduct of international and domestic arbitration in India in a most professional manner. More recently, on May 11, 2024, just a month before this Finance Ministry's office memorandum was issued, the External Affairs Minister, Mr. Shankar, was present on the inauguration of the Arbitration Bar of India. On this occasion, he spoke and highlighted that insofar as Government of India is concerned, the present government, right from its initial years, it has recognized the importance of arbitration. Describing arbitration as an efficient and equitable method for resolving disputes, Dr. Shankar said, whether in domestic or international arenas, arbitration inspires confidence, fosters economic growth, and upholds the rule of law. He also referred to his own experience when he was India's ambassador to Singapore at the functioning of the Singapore International Arbitration Center. Arbitration is recognized as the cornerstone of modern dispute resolution. He emphasized that high-quality arbitration is a notable factor in attracting foreign direct investment. As a foreign minister, he said his ministry recognized the importance of arbitration in facilitating international trade and investment, fostering confidence amongst foreign investors. Now, in complete negation of the Prime Minister's vision and notwithstanding the grand declaration of the External Affairs Minister, the Finance Ministry has come up with this set of guidelines. Now, this has set off a chain reaction. Both Oil India Limited and ONGC, two major public sector undertakings of India, have declared that they will not engage in arbitration in public procurement contracts if the disputed amount exceeds rupees 10 crores. In fact, oil has gone ahead a step further by saying that it would opt out of arbitration following the above guidelines. However, the icing on the cake is an office order dated 21/4/2025 of the Public Works Department, Government of Delhi, whereby it has decided to completely do away with arbitration altogether. This office order specifically says that the arbitration clause shall be deleted from the general conditions of contract of all future contracts of PWD. Instead of the arbitration clause, the following clause has been directed to be inserted. Any dispute arising between the parties to this agreement or contract shall be subject to the exclusive jurisdiction of the courts in Delhi. So now arbitration is out insofar as Delhi PWD is concerned. Not lagging behind, the Ministry of Road, Transport and Highways, Government of India, has now issued instructions on January 12, 2026 to all authorities, including National Highways Authority of India, that the existing clause of arbitration should be modified by specifically stating that any dispute equal to or above rupees 10 crores shall not be referred to arbitration. Friends, in India, most state governments and also the central government are engaging in economic activities with the help of financial assistance from international organizations like the World Bank, the Asian Development Bank, International Bank for Reconstruction and Development, Japan International Cooperation Agency, JICA. All these financial institutions, while advancing loans and in their loan agreements, insist that disputes between parties to the loan agreement or any claim by any party against any other party arising under the loan agreement should be subjected to arbitration by an arbitral tribunal. All these institutions insist that any financial transaction based on the loan provided by them must be subjected to arbitration in the eventuality of any dispute. Similar is the position with regard to the New Development Bank, which is an initiative of BRICS. Now, you are availing funds from these international bodies and engaging in commercial activities. These bodies, while advancing money to you, insist that any dispute arising out of these funds should be referred to arbitration. And what you do after getting the money, you say no arbitration. You go to the civil courts. This is absurd. Now, in that initiative, 2016, let me go back again, the Minister of Law and Justice was also present. And in that national conference, he said, he referred to Singapore and Hong Kong arbitration centers and said that the disputing parties are Indians. The lawyers arguing the cases there are also Indians. Then why can't they do their arbitration cases in India? He asked the question, why can't India become a hub of arbitration? And he said, we have to think in this direction. The answer is very clear. If this is the approach and attitude of the ministry, the Prime Minister's vision is something else, the Government of India's vision is something else, and the Babus do just the opposite, then the India become a global hub for arbitration would remain a far cry. The former Chief Justice of India, Justice Chandrachud, Dr. Chandrachud, he also expressed the view that arbitration is now central to commercial justice rather than a mere alternative dispute mechanism. It is apparent that the Finance Ministry's guidelines are clearly in conflict with India's declared policy and international commitments. The above steps, starting from the judgment in Delhi Metro, which triggered off everything, followed by the Finance Ministry's office memorandum, have greatly harmed India's cause. Those have diminished, rather damaged, the long-standing efforts to enhance ease of doing business in India by making India an international arbitration hub. The legislative reforms of 2015, 18, 21, and judgments of the Supreme Court also had systematically narrowed down judicial interference in arbitral awards by procedural clarity, in the process making India a more predictable forum for dispute resolution. But I am afraid, because of this Delhi Metro judgment and the follow-up steps taken by the Finance Ministry, will negate all such attempts. Can parties, I am asking myself, can parties, mostly government and government entities, who are unwilling to accept arbitral awards, be expected to resolve contractual disputes by way of mediation? According to me, this is far-fetched. And why should one put mediation against arbitration? Mediation is not a competitor to arbitration. Arbitration is not a competitor to mediation. Both can stay together and be used to supplement each other, just as the Prime Minister had suggested. Friends, I would conclude with the observation that erratic court verdicts, regressive policies like the above, they act as barriers to India's efforts to position itself as a global arbitration hub. If this is the approach of the authority, I ask myself, is there any need for celebrating arbitration weekends? Is there any need for hosting international conferences on arbitration in India? We need to ask ourselves. I would therefore urge upon all right-thinking people to seriously consider the damaging impact of such regressive moves and to ensure that arbitration, statutorily recognized and celebrated, continues to remain alive and kicking in India. We should not judge arbitration through the prism of, the narrow prism of retired judges getting plum arbitrations and making some money. Why should we fall into this? Stoop so low. We have institutions, let us strengthen the institution, strengthen institutional arbitration in India, and limit the scope of judicial interference, which is the legislative intent. And I am sure with the voices of the bar, the voices of the arbitrators, arbitration will continue to flourish in India, notwithstanding such regressive moves of the finance minister. I once again congratulate the organizers for inviting me to participate in today's conversation. Thank you very much, and God bless.
Thank you, Justice Bhuyan. We now move to the panel discussion on a topic for today, arbitration in India, reform, relevance, and the road ahead. I would now like to hand over the mic to the moderator for today's discussion, Mr. Amit Gupta, Senior Advocate, to moderate today's panel discussion.
Thank you, Muskan. Justice Bhuyan, for such a hard-hitting speech. I believe that the erudite views which you have expressed have actually taken steam out of the questions which we had sought to discuss. But we'll try our best to carry forth that discussion. If I may start with Justice Shankar, and it's one of the issues which Justice Bhuyan also discussed, insofar as the arbitrators are concerned. When an award is set aside under Section 34, and one of the grounds on which it is set aside is patent illegality, does it say anything about the training and the preparation gap as the arbitrator? Because most of the times it's on the procedural aspects.
Thanks a lot for inviting me here. Though it was stated that I have laid down a lot of law on arbitration, honestly speaking, I am not a person who is from this field, either when I was practicing or even after I joined as a judge. So if I have laid down anything, take it with a pinch of salt, as you should take whatever I am saying here on the forum today. Amit has asked, I really don't know whether we can put any blame on the training of the arbitrators, etc. Arbitrators, now we know very well, are across the entire spectrum. We have retired judges, we have persons of eminence, we have advocates, we have very outstanding awards coming from advocates. And generally we find they are persons who are duly legally trained and know the niceties of the law. And I don't really think that if awards are being set aside on patent illegality under 34, it is attributable to the training of the arbitrators or any kind of lack of proper perspective on their part. See, my understanding is the most important feature, which ultimately if an award is set aside under 34, it's done by a court. So the idea is what should be the perspective which a court keeps in mind when it deals with such a situation. And the most important thing, according to me, is the fact that, and that is something which Justice Bhuyan also mentioned in his address, that we must understand arbitration is not adjudication by a person of your choice. In fact, I must tell you very honestly, yesterday or the day before when I told someone that I was attending this arbitration, this conference, someone who was not mercifully well trained in arbitration. So his argument was, what's the big deal? After all, what is arbitration? You don't want to suffer the rigors of a court. So you choose a person between yourself and he'll do the job. That's all it is. It's just a substitution. Now that point of view is completely erroneous. And that point of view has to change. And if that point of view is changed, many things would solve. Because we must realize arbitration is not adjudication by a person of choice. Arbitration is a way of resolving a dispute in a particular institutionalized format. Now, when I say institutionalized, I don't necessarily mean through an arbitral institution. The institution of the arbitrator itself is an institution through whom we are getting that dispute resolved. And our idea should be to see that that resolution works. It's not that we are going to treat it like another adjudication and we are going to subject to the same rigors of adjudication. So that is the first perspective change we need. The second point is, we must bear in mind Section 5 of the Arbitration Act as a guiding principle for Section 34. Section 5, though it says, of course, that there must be minimal judicial interference limited to what is stated in the Act, we shouldn't treat that as a ground to say that we can now expand it, go into 34 and start interfering. Section 5 is a guiding principle that you should not interfere, if possible, with arbitral awards. And there are, as Justice Bhuyan said, and as we all know, starting from after Associated Cements onwards, there has been through SsangYong and all those decisions, there has been a wide plethora of authorities on the point that there should be minimal judicial intervention, and we must keep that in mind when we are dealing with the philosophy of Section 5 must be borne in mind when we are dealing with a Section 34 challenge. The third point we must understand is that the clause, see, I have a personal view that Section 34 is a very badly worded provision. Except for the provision which deals with patent illegality, it brings in concepts such as fundamental policy of Indian law, etc., which according to me means nothing. I don't know if Indian law even has anything called a policy. And then to say that what is Indian law, what is a policy, and then what do you call a policy fundamental? All these are major issues, but they are not dealing with patent illegality, and so I'm not going to that here. The question asked to me is of patent illegality. Now, so far as patent illegality is concerned, the provision itself says that you will not reappreciate evidence and you will not interfere with the award merely because there is an erroneous application of the law. The word is interesting. It's not erroneous appreciation of the law. It is erroneous application of the law will not be a basis to interfere. And you will not also interfere by reappreciating evidence. Now, if we keep these principles in mind and work in the background of Section 5, I don't see why we should find, I think a majority of arbitral awards would pass muster. At least they would not be interfered with by a court as though it is sitting in appeal. The last point which I want to mention on this point is DMRC. Now, Justice Bhuyan, sitting where he is, has the liberty to say, the latitude to say that it has done things and caused damage and things like that. But sitting where I am, when DMRC is cited before me, I have to find a way around it. So it is true that DMRC has interfered. And if we look at DMRC seriously, and I mean, if we look at it as a whole, it may appear to be an aberration from the general principle of not interfering in with interpretation of contract. That was actually a case of interpretation of contract. But if we actually, I mean, this is only with a view, frankly, to seeing how we can overcome DMRC and harmonize it with the law otherwise declared by the Supreme Court of minimal judicial intervention. And there, if we see the issue that arose in DMRC, the question was of whether effective steps had been taken to cure the defect. That was the issue in DMRC. So the arbitrator, the clause read that the defect should be cured or effective steps should be taken by the contractor to cure the defect. That is what the clause read. The ground on which DMRC chose to interfere was that the arbitrator has omitted to notice the second part of that clause. Because the arbitrator has merely said that the defect is not cured, the arbitrator has not examined whether whether effective steps were taken to cure it, and so DMRC in a sense held that you have misread the clause. You have read the clause in part, you have omitted to read half the clause, and therefore it becomes a case of reading the clause in a manner in which no reasonable person would read it. So that was the basis on which, that is one way of getting around DMRC, that's all I can say. But that seems to be the manner in which DMRC it sought to interfere despite the fact that it was a case of a contractual interpretation. And even when it came to the heading of appreciation of evidence, DMRC said, since you did not read the second part of the clause and you read it only in part, therefore you did not appreciate the evidence which indicated that effective steps were taken. So I have not frankly had necessity to go around DMRC, but this is one way of negotiating it and bringing it in line with the law. So otherwise the law is all one way, and if we keep it in sync with section 5, we should not have any difficulty in pushing forward the philosophy of non-interference. I don't really think it can be attributed to any lack of training or any lack of proper appreciation. We have to keep in mind the fact, as I said in the beginning, that arbitration is not adjudication by a private party. It is basically a way of dispute resolution. That seems to me to be the way ahead, to see that there would be less interference in section 34.
Thank you, sir. My next question is to Justice Bhuyan, because he touched on the issue of the IBI guidelines, and it's also pertaining to the arbitrator. When a court appoints an arbitrator under Section 11, would it be better that they have a panel of arbitrators strictly in terms of the guidelines as well as their expertise, or we should leave it as it is, which is the current situation where a Section 11 court is free to appoint in case the parties are not able to come to a settlement as to who will be the arbitrator?
I feel that Section 11(6), some high courts have a panel of arbitrators, and the Section 11(6) judge normally appoints arbitrators from that panel. I don't know about whether it is a uniform practice followed in all the high courts. Delhi it is followed, Parent High Court it is followed. But if you leave it to the Section 11 judge, then appointment takes place on other considerations. I have a good equation with a retired judge, and I feel that he is more attuned to commercial litigation, he understands commercial law well, so I'll appoint him. There also I find there is some sort of lopsided, and again, it is mostly there also, instead of sending it to institutional institutions, we are sending it to mostly retired judges, and thereby promoting again ad hoc arbitration. So I feel it has to be a mixed bag. If you have a curated list, now that list, if we stick to that list, it may shunt out newer talents and persons from outside the legal field who would be in a better position, for example, engineering contracts, etc., to arbitrate in matters. So therefore, it is actually both. It has to be a panel list, and also the discretion should be given to the Section 11 judge while making an arbitrator. But I would insist that institutional arbitration should be given priority. Retired judges should be requested to empanel themselves before this institutional body. Otherwise, what is happening? Some of them are overworked actually, having 10, 11, 12 arbitration at a time. Mornings, one session, afternoon, one session, evening, one session, sometimes night also one session. So one can think of a cap also, that if you have this many arbitration, beyond this, no. So, and this is perhaps what actually worked out with the finance ministry people also. So my view is this: we should have a mixed bag, both the curated list as well as some discretion to the judge, but preferably institutional arbitration. Thank you.
The next question is to Justice Rajiv Shakdher, and again it's pertaining to the IBI guidelines. There have been several cases now where after the incorporation of those earlier guidelines into the Act, where even a successful party has gone ahead and challenged the award on the ground that the appointment was unilateral. So is it that the pendulum is now swinging a far too bit extreme, in the sense that in the process of enforcing those impartiality guidelines, that now a party appointing an arbitrator has an easy way out to get the award, set it aside once it goes against it.
Yeah, I won't get a chance to congratulate the team which has organized this. So therefore, Amit, before I answer your question, I must congratulate you for organizing this. And I think one of the reasons why I think these platforms are important, it is like a forum for continuing legal education. However boring you may find a conference, and I know the attention levels dip after 20 minutes. That's what the TED Talk convener would often say, people go to their phones, etc., etc. But both for the audience and for the panelist, you sort of relook at the law, you analyze it. So therefore, this is good, and I completely congratulate your team. Now, on the question of unilateralism, my answer is actually twofold. The judgments of the Supreme Court, starting with TRF versus Energo, Eastman Perkins, Bhadra, has now declared the law that unilateralism will not work. Any unilateral appointment will result in the award being declared void. The question is, who seeks this declaration? Bharat Broadband is a case where the public sector undertaking appointed or got an arbitrator appointed, then moved an application before the arbitrator saying you can't operate because of the 2015 amendment. The arbitrator rejected that application. An award was delivered. At the section 34 stage, he sought to set aside an arbitrator which the same entity had appointed. The matter from 37, where again the objection failed, went to the Supreme Court. Now the judges who decided Bharat Broadband were one of the best commercial judges. I had, and I can only tell you from my experience, and that's my objection with the trend of the judgment, and this has not been decided, is a similar situation came, and the lawyer who appeared in Bharat Broadband was also the lawyer who was before me. And he raised a similar objection when I chose to frame a question, which I don't know whether it got answered by my successors, because by then I had limited office here, is what about the costs? You lulled the other party into accepting arbitration mechanism which you yourself found fault with. I can understand that because law declared by the Supreme Court is binding under Article 141 on everyone. But the other facet, that should you not pay the costs of arbitration, that the other party which secured an award suffered, because the award that the successful party got was quite substantial. Now this is an area which I don't think any court has answered till now. Again, subject to correction, the Supreme Court needs to intervene. If you are going to set aside awards, then someone must pay for the time and cost that was incurred both by the administration of the court as well as by the parties. That's point number one. The other is, there is a proviso to section 12.5 which says that if after the disputes have emerged by an express agreement, written agreement, you could do away with this problem of unilateral appointment. So the way it was interpreted in Bharat Broadband was that such an agreement should be after, because what emerged in the cases that I referred was that when you went before the arbitrator, you actually agreed to his appointment. So was that a written agreement? The court of course said no, it was not a written agreement. Often we record settlements when counsels are there in court, and then that operates as a decree. So my issue is, and something that all of us need to consider, was it a void award or a voidable award. We know the difference between void and voidable. So when parties agree to such a mechanism and say, please record it that I have no objection to you, A or B, functioning as an arbitrator, does that give some window for saying, no, this gets out of unilateralism? I don't know, but the law, as declared by the Supreme Court, has moved in the opposite direction. They have just gone ahead and applied Bharat Broadband and other cases that have followed and said, no, you can, and applied the judgments under the CPC, the old 1954 judgment, which is Chaman versus Kiran Singh, saying an issue of jurisdiction can be taken at any stage, even in collateral proceedings. The point is, do you factor that in arbitration proceedings where you chose a judge, you made your bed, and now you don't want to sleep on it? Whatever you do, someone should pay for this U-turn. That's point number one, and I think if Justice Bhuyan gets opportunity, maybe, of course, after hearing counsel for the parties, because we are the very same persons. One side, now I am a lawyer also. So one side says, it should be done. The other side says it doesn't. So in an adversarial system, it works both ways for lawyers. We get paid for both, But the iteration and the ideation has to be done by the court declaring the law. So therefore, this is my view. This pendulum has swung, but like other cases, it may swing back, and some court may dwell on it and may come to a different conclusion. The Delhi High Court could work on costs, and then the matter could travel up. That's my answer.
Just to add on it, sir, there's a recent empirical study of cases which have been filed in the Delhi High Court from 21 to 24. This has been published just last month. And it said that insofar as the composition of arbitral tribunal is concerned, they had the highest success rate to the extent of 75%. Again, relying on this very basis, that the arbitral tribunal has not been constituted properly.
Okay.
My next question, I'll have it, I would want to have the views of all the panelists, but I would start with Justice Bhuyan. Sir, you mentioned about the institutional arbitration. When we think of institutional arbitrations, the two names which generally come to our mind is SIAC or Hong Kong Arbitration Center. In India, we have tried to make a lot of efforts, even by way of statutory amendments, to have institutional arbitrations put in place. But what we see today is that there is a proliferation of various arbitration institutes, so that there is no one arbitral institute which comes to mind when we speak of India. Do you think that we should have one premier institute which will then have offices or branches in various cities, or we should let the various institutes grow just because of our diversity? I'll start with Justice Bhuyan, sir. What would be your views?
See, the government of India actually had this in mind when it created the New Delhi Arbitration Center, now the India International Arbitration Center. Justice Hemant Gupta, former judge of the Supreme Court, he was the chairman there. So we meet in the morning. I go to the Supreme Court gym. He also comes there occasionally. So I was just asking him, sir, what is your, how many arbitrations are you handling now? He said, no arbitration. Nobody comes. So this is the position. This is it was supposed to be a flagship institution. And now Gupta has retired. Justice Gupta has retired, is lying vacant. It's completely defunct. So this is the position. Now, Delhi Arbitration Center, it is there, it is doing good work. Mumbai also, it's got, in recent times, it's got a lot of work. Considering the size of our economy, size of our country, it may not be appropriate to, it can't be actually to have only one institutional center, unlike in Singapore or Hong Kong, because it is obvious, Hong Kong and Singapore being the size of that country. But then we must also ensure that there is some quality when we start this institution. I was Chief Justice in Telangana, when a private trust, earlier, before I became Chief Justice, a private trust was created to have the Hyderabad Arbitration and Mediation Center. Hyderabad International Arbitration and Mediation Center. It's a private body. Of course, there were eminent retired judges of the Supreme Court in the trust there. And the government of Telangana also said we'll do the finances. And the procedure adopted was that the money will be deposited with the High Court. High Court in turn will give it to the trust. High Court had no control over the trust. If something happens there, how the High Court will resolve this issue? And there were a lot of criticisms at that point of time. I remember Sriram Panchu had written one article in the, I think, Times of India or Indian Express on this. Luckily, now the money through the High Court has stopped. No High Court judge, all the benches there, we had about 3-4 benches there in Telangana, Section 11. None referred this, any cases to the Hyderabad Arbitration and Mediation Center. So these are also there. We have a mixed bag kind of thing. Delhi Center is doing well. Mumbai Center is picking up. I'm sure the Bangalore and the Chennai ones are also picking up. Rest, I'm not very sure. So in a country of India's size, it will be advisable to have more than one center and let there be healthy competition among the center. Each should then, we can make a provision that all, whoever wants to arbitrate, retired judges, engineers, etc., should get themselves enlisted in those institutions. At least this is my personal view.
Shankar sir, and specifically in the context of DISC since part of the institution.
So you see, I have attended quite a few conferences where this issue has arisen, has been discussed about why people are not willing to come to India or come to arbitral institutions in India for resolving their disputes. And though there have been talks this way, that way, but I don't really think we have come down to identifying any real parameter why, what's the problem. So far as infrastructure is concerned, we have the infrastructure. DIAC, I'm honestly speaking, I'm not really sure of what the present position is. There were certain hiccups in DIAC at the time when I was sitting as a single judge in Section 11 jurisdiction. There were certain parties who really did not want their dispute to be sent to DIAC because they said it's overworked and it takes time to get an arbitrator appointed and things there are. But those are all, you know, I think issues which can be ironed out. That can't be a reason. I more think that if probably the disincentive lies not in the institution as per se, but in the problem that arises once an arbitration is in place. If we manage to give confidence in a foreign investor or a foreign company or outsiders that we will give them the same degree or at least some comparable degree of certainty in an arbitral proceeding as they would get from an outside or from Singapore or Hong Kong or London or Dubai or whatever it is, then probably the footfall would increase. But so I again think the idea is that the overall arbitral institution has to be pushed forward and we have to inculcate a feeling of, ensure that there's a feeling of, of comfort in the person who wants to have the arbitration decided. That yes, if I go to this institution, it will be done and it will be done in a reasonably efficient manner and I am likely to get a result. Of course, the result this way or that way, but I am likely to get a result and my dispute will be resolved. I will not have to suffer years and years of litigation for it. If we manage to do that and we have a reasonable infrastructure in place, I think perhaps it might be even more economical for persons to come here, provided everything is in place. So I think that should lot of good for the. Otherwise, there's no real reason why people should not be choosing India. And like Justice Bhuyan just said, it doesn't really matter whether it is one institution or 4 institutions, provided the institutions, they pull their socks together or put their act together and see that. I recently attended last year the inauguration for the Chandigarh International Arbitral Center. Now, I don't really know what's happened after that. They inaugurated it with great fanfare, and they said that they still hadn't got a building from where they could function. So they said a piece of land has been identified. I mean, the function was so grandiose. I thought, before I went, I thought it's all in place and we've done the function and tomorrow this is going to start. I find out they don't have a building. They said, of course, that they are getting things together. They've located an area and it will take about 2 years to set it up. I mean, so we have to be more efficient, and if we manage to do things in time, I think we should be able to get people here. That's my...
I'll just add to what Justice Shankar has said. I think issue is not there. Infrastructure we have got, and as the Prime Minister has said, we have a pool of eminent lawyers, judges, retired judges to handle arbitration. I think the core issue is the fear, the lurking fear of foreign investors, including Indian, not only foreign, Indian parties also about the Indian courts. When they will interfere, to what extent they will interfere, after how many years they will interfere, till they get the money, till the award is fully executed, satisfied, this fear remains in them. So therefore, not only for foreign investors are hesitant from coming here, Indian parties given an opportunity would like to go abroad and settle their, because they want to be assured that this kind of uncertainties do not go plague them all the time. This is a fear of I'm sorry to say I'm part of it. There is a fear of the Indian courts. That is one of the main crucial factors.
We'll open the
we'll come to that.
Justice Shakdher, how do you see, as a former judge and now as an arbitrator, what would be your views on it?
Things that I must clarify, because retired judges are getting a bad name. I like to call myself... And I quite agree with Justice Bhuyan. So therefore, I like to call myself with a hyphen, attired judge. And however much I may like to move away from arbitration, there are colleagues who perhaps I can say have some trust and they send it to you. But left to myself, I would do more litigation, less arbitration. But the point really is this. I'll come back to the point that the issue that you raised is, and I completely agree with Justice Bhuyan that there should be a cap. Now, the form that you fill up actually is like a self-regulation form where they say, do you have enough time, etc., etc. So we may come to this other part is what are the reforms that we can make. And one of the reforms is a statutory cap. In certain matters, you shouldn't leave matters to discretion. Lawyers also know you make a declaration and then that's it. But should we have one arbitration center for the entire country? And I agree again with Justice Bhuyan, for a country of our size, with the kind of population that we have, language, ethnicity, the nature of disputes, that's neither feasible nor practical. You could have major hubs as arbitration centers, and then as it grows in 2-tier cities or a 3-tier city as well. The point is, how much autonomy do they have? The problem with us is, somewhere at the back of the mind of those who legislate, those who administer the ecosystem, want control over arbitration. So if you see the amendments which have not been enforced, which was in 2019, we have an Arbitration Council of India. It's like the Bar Council of India, which will, govern. There are some good parts that I think we can adopt. But governing arbitrations like this won't happen. Why is Singapore succeeding, Hong Kong succeeding, or the London International Arbitration Center is they have an element of autonomy. There is someone equivalent to a CEO. They have a battery of people who are professionals who run the arbitration center, and they have impaneled lawyers, judges, whoever want to get impaneled. They look at your CV, your track record as a judge, and then they impanel you. But there is no control from any court or the government. In fact, I don't think even Justice Shankar was part of the court when this center was made, the Delhi High Court Arbitration Center. We started by Chief Justice Shah was there. And the way he conceived it, and it happened actually on the penultimate day of his retirement, he had a very grand function. It was introduced. It was a thought worth taking forward. The way he conceived it, that's how I understood his idea, was this will move away from the court. It will be an independent, autonomous institution. Of course, with the change in the helm, this was reversed. So therefore, to my mind, it is again a question of trust deficit. You know, I will feed a particular institution in the sense I will send matters to them, but I must have control. But you already have control through legislation. When they render an award, you already have control. If there is a problem, it can always be set right. But on a day-to-day functioning, unless you give them the autonomy, you will not come to that level as Singapore Arbitration Center. And you must also remember this won't happen. There are city-states. We are a country. We are almost a subcontinent. It won't work. So you can have best of both worlds. Secondly, why does Singapore attract, I'm giving you an example of Singapore, why does it attract international arbitration? There is no trust deficit. They actually have an appellate court, all of you know now, of judges from across jurisdictions. You have an American judge sitting, you have Indian judges sitting, you have a Singaporean judge sitting. So the government supports this. The moment you have an Indian judge sitting, or I don't know, a lot of people would sort of get a sense of confidence. Okay, I can go to Singapore. Or an American judge sitting, an American or a Japanese company would come there. We kind of, as I said, we want to control the whole thing, and therefore there is a problem. The third problem is more recent, which again, in his lecture, oration, he pointed out, is this flip-flop on the law. So 3 judgments, according to me, have taken diametrically opposite view. One is control, that is Balaswamy. Of course, DMRC is there. And then came interplay between arbitration agreements and, stamping act, the Stamp Act, where they've again narrowed it down. Now, I actually empathize with High Court judges. They're left to grapple with it, and just as Shankar pointed out in a very oblique fashion, if I was in his place, I would have said the same thing. It is beyond my pay grade, correct? I cannot do, and he's bound by law. See, as a judge, it's like playing any game. You're bound by the umpire's decision. Now, the umpire here is the Supreme Court. Under 141, it is declared the law. But creative judges find the way. We have history for this. When saw pipes came, I was a middle-level judge, and I saw how saw pipes was playing out. And all the senior judges who sat there, they navigated it. Saw pipes, correct me if I'm wrong, was actually never, ever, rare occasion, applied in the Delhi High Court. Because it was, and mind you, they were eminent judges. I think if my memory serves me well, O. Chinnappa Reddy, who rendered the award. O. Chinnappa Reddy was one of the brightest minds that anyone who's practiced in the Supreme Court would have known. And, but 2-judge bench saw it fit to introduce all these ambitions. But the point being, these judgments are an exception, and I'm sure creative judges with judicial tools can get around it, and therefore maybe Supreme Court would reverse this. So yes, to answer Amit's question, It is not really whether you have one or two. In India, you can't, it's our view. It can be always contested. But you need to have autonomy, and you need to have Supreme Court declare the law in a fashion where, arbitration institutions can work.
I will change the topic a bit to technology and AI. And I would request Justice Harishankar's views first on this. In today's time and age, we have virtual hearings, and arbitration is also technologically driven. As AI enters the case management, research, and decision support systems, where should the line be drawn between efficiency and human adjudicatory responsibility?
See, on this, my view is arbitration agnostic. I am not, so far as AI's intervention is concerned, whether it is arbitration or adjudication, I am fully in agreement with what the Supreme Court has been saying in recent times about AI and its the extent to which it should be used. There can be absolutely no question of any judicial decision being in any way, even to the remotest extent, guided or governed by use of AI. And that would apply equally to arbitral awards. Now, when I use the word guided or governed, what I mean to say is, from beginning to end, in my understanding, a judgment or an award has to be the creation of the author of that judgment or the arbitrator rendering that award. I am even against a practice of having facts written by someone and putting in the reasoning thereafter. According to me, the first word to the last word of a judgment has to be the creation of the judge. There can be no question about it. Because sometimes, even in the manner in which it is written, it reflects the approach of the judge, it reflects the approach of the arbitrator, if it is an arbitrator. And therefore, AI cannot, of course, be ignored. And AI has a large role to play, but that role has to be restricted to the research aspect. You can use AI for research. We do it. Today, in fact, if you, not just law, on any topic, sometimes if you put in a query on Google, it is the AI research which may be more reliable than the other research, the other results which it throws up. Because of course AI is more comprehensive. It goes through the entire gamut of the internet or whatever is available in the public domain and then gives its result. But beyond that, the use of AI is something which should be completely foreclosed. And again, when it comes to research also, I am hearing horror stories of how judgments which don't exist are now being thrown up, which means now we will have to subject the AI results also to a filter. But yes, it can to some extent facilitate expeditious getting of material which can help in rendering a decision. Beyond that, I don't think AI can really be of assistance, and the same principle applies equally to adjudication as well as arbitration. I was told that there are some tools now which can be used to condense arbitral awards. So for example, when we are sitting in a 34 jurisdiction and we have an award of 500 pages, you can't, instead of sitting and reading 500 pages, I believe there is some software you can use and it will condense it down. And I actually, a friend of mine had given me a demo, but the result was awful. So I don't know how far that really works. But beyond that, it has to be ultimately the reasoning of the arbitrator, the reasoning of the judge, and the same principle applies across arbitration and adjudication, so far as my understanding goes. And I am not much of a fan, I am not much of an very adept at AI. I don't even know how to use ChatGPT. So you must take this from the point of view of someone who is AI innocent.
That's surprising, sir. I thought you were technologically savvy using Dragon.
Dragon has nothing to do with AI.
My closing question to the panelists before we open the floor to the audience, and it would be to each one of you, sirs. Given an opportunity to introduce one reform, legislative, judicial, or institutional, that would be most significantly improving the arbitration in India over the next decade, what would be it? Justice Bhuyan.
No, as I said, there should be a cap on the number of arbitrations an arbitrator handles at a given point of time. This is one specific thing. Yeah.
Yes, I mentioned it earlier as well, that one important legislative reform I think which is needed is clarifying this aspect of what's it called? Indian policy, what fundamental this thing of Indian policy. I really don't know what that means. And I've gone through all the decisions of the Supreme Court on the point. Each of them is putting, in fact, a chronological list of the decisions which have tried to explain what is fundamental policy of Indian law. So I have not really come across a very satisfactory understanding of what it means, except for saying that, natural justice should be followed, and some judgments say that the decision should be as any reasonable person would look into it. Now, what is reasonable? That becomes something again. So I think there is need for either judicial or legislative precise clarification of what this expression fundamental policy of Indian law means. Because there is also a decision which says, I don't know if it's DMRC or something else, or maybe something else, which says that this expression fundamental policy of Indian law should also inform the court when it is examining a case of patent illegality. So that kind of conflates these two parts of section 34. So it becomes important to know what it means. And I think that has to be clarified. So if I had it with me, I would have definitely seen that that aspect is clarified, because it's creating a lot of, it makes it wide open if we give it its widest interpretation.
Justice Shakdher, sir.
So as far as judicial reform is concerned, actually you can't pin it down to one. There is so much that you can do, and when they are looking at this bill, they should actually ask for comments. The most disastrous thing is having an appellate tribunal. Taking a cue from there, I don't know whether they could think of having only one challenge in the High Court rather than inter-court appeal. The intra-court appeal can remain because 136 power is in the Constitution. And 34 can straight away go in every High Court, or whichever court, if it's court below, to one court. If it's the district court, then from there, perhaps straight to the division bench, rather than a single judge or whatever. So you could remove one forum. That's a suggestion that could be worked on. As far as the judicial reform is concerned, the answer is no-brainer, which is the least amount of judicial interference. You can't be that creative that you have curative jurisdiction kicking in. Administratively, that's the third limb, or you want only on judicial?
Yes, sir. Either legislative, judicial, or administrative, which you would feel is the best to be done?
No, judicial and this should work. Administratively, we've all discussed here. Empower arbitration institutions, move away from ad hoc arbitrations, because litigants at the end of the day entertain distrust. And one thing that I may end with on this is, once again, when I was heading the arbitration committee in Delhi, I had asked, because on the committee you have the ASG of the Delhi High Court, senior advocate, and other members are there. So I had asked them, why don't we grade awards on an anonymous basis? And this is the onus, I'm throwing it back on the bar. And they said, sir, we can't grade. I said, when you grade examination papers, you can have a committee grading it. On an objective parameter, subjective you can't, because everyone has his own style of writing awards. When did he enter reference? When were issues framed? When was, examination undertaken? This is on the delay part, because at the end of the day, what ails the system is delay and costs. And you do it like you do it in an examination. So if a former judge asks you, did you grade? And the grader will say, listen, I don't know, I was given a number, I graded the award the way I wanted to, or the proceedings the way. But no one was willing to catch that hot potato, as I call it. Interestingly, it's got unnoticed, and I have said it at other forums also. Section 43D 2C, which came in by the 2019 amendment, it says, apart from grading the Arbitration Council of India, whether we should have it or not is nothing, apart from grading such institution, you can grade the arbitrator also. Now, should you go that way or you shouldn't go that way? Some former judges will have a view or the lawyers will have a view. But I thought on an anonymous basis, because the litigant should have a menu. Like you do when you give, you should have a menu. These are the arbitrators I have on my panel. This arbitrator has done oil and gas disputes. This arbitrator has done construction disputes. So certain amount of domain expertise. You can have an engineer, you can have a retired judge, you can have a senior lawyer who's worked in that area. And that, you know, his performance is XYZ or whatever. Here the litigant, when he goes in and an institution appoints, he's actually in a blind alley. He doesn't even know how it's going to turn out. So these are those reforms, if you undertake or at least debate, there could be some change. Capping, I completely agree. And I'll be the first one to give up whatever has to be.
I guess there's a conflict of interest when you say capping.
No, there's no conflict of interest. There's enough work for everyone. And as I said, more and
That
more
was a
judges,
yes,
at least
sir.
from the Delhi High Court, have taken to retiring.
Thank you, sir, for such engaging responses. We have one question from the audience, a student member.
Navnoor Singh Sethi has a question to ask.
Is he present?
He's there.
Could we get the mic to him, please?
Hello. Yeah. My greetings to the panel. I am Navnoor Singh Sethi, pursuing my law degree from OP Jindal Global University. My question to the panel is, what is the purpose and scope of an arbitral award if it is not binding and is perceived as only a precursor to the court proceedings?
See, purpose of an award is adjudication at the end of the day. But the aggrieved party should have at least one forum. You can reduce the number of forums, but it should have at least one forum, and with that discretionary remedy under 136 if they decide to enter it. Because if you don't have that, then, you know, there's going to be a problem in a country like ours. So, and not an appellate tribunal, certainly not an appellate tribunal. That's my short answer.
And there is one Ms. Sonali Gambhir who has a question.
My question is, given the current momentum towards institutional arbitration in India, what limitations or unintended consequences...
No, just switch on the mic, please, and introduce yourself.
My greeting to the panelists. My name is Advocate Sonali Gambhir and I am a practicing advocate. And my question to the panelists is, given the current momentum towards institutional arbitration in India, what limitations or unintended consequences should we be mindful of?
What consequences should we be mindful of
Yes.
for institutional arbitrations?
Yes, given the current momentum.
No, institutional arbitration has its own benefits, and it makes it a very structured process. Unlike ad hoc arbitrations, it entitles you to the infrastructure of the institutions. It has its own discipline with which it proceeds. If the institution is one which is conducting the arbitration, there should be no unintended consequences, because ultimately the arbitration will be done by the arbitrator. So the award would be challenged as any other award, would be subject to whatever rigors any arbitral award would be. But it's for the institution to put its act in place and see that it is properly administered. Otherwise, it can result in fostering discipline in the arbitral process and ensuring that it proceeds in a streamlined fashion. So there should be no unintended consequences if it is a good arbitral institution.
Would be in a position. We get the mic, please.
Sir, I am Rajiv practice Supreme Court. As I said, people are fearing for coming to India. So how to, reduce their fear, or how best we can, go to international forum?
No, your question is like how to reduce the fear.
Yeah.
Well, there's no one straightforward answer here. There has to be multiple factors. As I pointed out, there has to be multiple factors. If you look at the statistics, most of the 34 where government or government enterprises are a party in India, right now government is a major litigant, whether it is in the arbitration world or in litigation. You'll find majority of the challenger petitioners are the government, state. If this is as Justice Shakdher has pointed out, if there is some autonomy given that this type of matters will not go and file a challenge there, I think it will, the problem will be solved to a great extent. But again, we have the problem of polyvocality in India. That's a big issue. We have 600 plus High Court judges in India. At least 100 deal with commercial matters. All their views may not converge. And as we have seen, including in Gayatri and then the previous one in Delhi, from Delhi High Court, we are as if we are trying to find out ways and means of how to intervene more and more into arbitral level instead of the reverse, going the reverse way. So unless we curtail this tendency, it will be difficult. And I don't see any short-term method to prevent this. Because in the Supreme Court itself, it has been pointed out recently, there was a book, 75 years of the Supreme Court. Then Chief Justice of India, Justice Chandrachud, said that, yes, we do have polyvocality, but he said it is good. Polyvocality, it reflects the diversity of views, and that's how a democratic discourse should be. In the same volume, Justice Ravindran writes that this is one of the biggest issues confronting the judiciary. Now, particularly in the Supreme Court, we don't have a uniform view. I may have a view of least interference, but one of my colleagues may have a view that no, this is a matter where we should interfere. There are small issues also on the venue of arbitration, whether we should go to London or not. When both parties have agreed that we'll abide by the rules of London Court of International Arbitration, just because one of the parties happens to be a PSU, they file a writ in the Telangana High Court. It was dismissed. Then SLP files. The SLP bench was about to intervene. Somehow, the order was not passed when I was there. Then thereafter, I don't know. I didn't know what happened thereafter. So we have to. This is a big issue, and there is no straitjacket answer to the apprehension that you have expressed. That is an apprehension in the minds of all parties who are going to arbitration, foreign or domestic. This fear of 34, fear of 37, fear of 136, fear of curative jurisdiction, at what point of time it will spring up like a, like a dormant volcano remaining there, and any moment it will burst. This fear will, as long as this fear will be there. So we need to have a concerted a dialogue. So therefore, dialogues like this, conversation like this, I think is most welcome, and it will help in building up a consensus. Thank you.
Thank you.
Thank you to all our
I want to put this to Justice Bhuyan. At least I used to feel that all of us as judges, by training, are interventionists. We intervene. That's our training. That's our mindset. If someone brings a issue and we feel, no, this is wrong, and this business of having 800 judges, and all of us have a view in the matter, I wonder whether part of our training, which some of us sometimes forget, which is the jurisdiction in which I am operating. If I am writ, my role is different. If I am in a suit, my role is different. If I am in an arbitration roster, so your natural tendency perhaps needs to be curtailed. And some of them have done phenomenally well, and they've said no if it's arbitration. Because it's like a picture on your wall in the home. Every inhabitant comes and straightens it out. Correct? You go there, no, this is not right, this is not right. That's precisely the tendency that you need to sort of curtail. I think.
Thank you to all our participants for these thoughtful questions, and a sincere gratitude to our distinguished speakers for their valuable insights and illuminating responses. To conclude the program, I now invite Mr. Yashraj Singh Deora, Senior Advocate, to deliver the vote of thanks. Thank you.
Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court, India. Honorable Mr. Justice C. Hari Shankar, Judge Delhi High Court. Honorable Mr. Justice Rajiv Shakdher, former Chief Justice, High Court of Himachal Pradesh. Learned senior advocates and members of the bar, and distinguished guests. It's my privilege on behalf of the Law Forum to propose this vote of thanks. Arbitration in India, I suspect, like a lot of things these days, is also inspired by our mythology of Samudra Manthan, the churning of the ocean, which yielded in equal measure poison and Amrit. We seem to have stayed faithful to the source material, as arbitration reform in India has thrown up much the same mix. The Amrit is plain to see. Party autonomy, the promise of speed and finality, and a jurisprudence that at its best insists on minimal judicial interference. But that same churning has also released its poison. Enforcement proceedings in arbitration that stretch so long that an arbitration award becomes a paper victory. And as Justice Bhuyan reminded us this morning, the curious spectacle of the state itself losing faith in the very mechanism it once championed. What today's discussion required and what it received was speakers willing to hold both the nectar and this poison up to the light without flinching from the one or overselling the other. I must first express my deep gratitude to Honorable Mr. Justice Ujjal Bhuyan for the keynote address and for engaging so directly with this very contradiction, both in the judiciary and the executive, in a government that speaks of arbitration as a plank of ease of doing business, while quietly writing itself out of arbitration clauses when the stakes rise, alongside questions of institutional consolidation or institutional diversity. We thank His Lordship for having found time in a demanding Supreme Court calendar to be with us. And this courtesy, this forum does not take lightly, and we are very grateful for Justice Bhuyan for taking the time out to be with us here today. My thanks equally to Honorable Mr. Justice C. Hari Shankar, whose contribution brought doctrinal rigor to questions ranging from patent illegality and the unruly horse of fundamental policy, as my lords pointed out, to the proper limits of technology and AI in adjudication, and to Honorable Mr. Justice Rajiv Shakdher, whose candor on unilateral appointments and giving autonomy to arbitral institutions, and the arbitrator's chair itself gave us a rare, unvarnished view from experience. Together, the panel gave us not a lecture, but a genuine exchange, marked by enough respectful disagreement to keep it honest. I must also record our gratitude to the honorable judges of the Delhi High Court and the many senior advocates and members of the bar who set aside their Saturday to be present. My particular thanks to my colleagues at the Law Forum, without whom this morning would not have been possible. Mr. Amit Gupta, senior advocate who has moderated today's discussion with such skill, Mr. T.M. Singh, senior advocate, Mr. Akhilesh Dubey, Mr. Harshvardhan Jha, Mr. Ali Mirza, Mr. Pratik Mehta, and Mr. Ritesh Kumar advocates for the work that went into bringing this conference together. I would also like to thank the Delhi High Court for so graciously making this venue available to us. And to everyone gathered here, thank you for your attention and for the questions that sharpened this discussion even further. The arbitration bar in India is fortunate indeed to have judges sitting and retired, willing to engage with it so openly. On behalf of the Law Forum and all present, I thank you once again, and I understand lunch now awaits, so I shall not delay us any further. Thank you.
With this, we come to the conclusion of today's program. Lunch has been arranged and everyone is cordially invited to join us. On behalf of the Law Forum, thank you once again for joining us today. Wish you all a wonderful afternoon.